So can we start? Hello? Hello? Can we start?
Yes, sir.
Hello?
Yes, sir.
You can start now. So my presentation is visible? Hello, it is visible.
Yes, sir. Yes.
Okay.
Yes, sir. Yes.
Okay, before I start, I just want to make a clarification here. You know what I say? That your repayment plan will also include the claim if any received from the operational creditor. And based on the entire claim, financial creditor and operational creditor, the personal guarantor will exhibit whether he is able to pay the debt of the financial creditors. There is no question of payment of operational creditors debt or financial creditor debt. The resolution plan will say that yes, in this way we will are able to pay the financial creditors with the terms and conditions how it will be paid. And if the financial creditors agree, the committee of creditors will approve the resolution repayment. Okay. So the
No, so
total
means you are saying it will. So, so this is what you were saying earlier also, I suppose.
exhibit, I want to say the exhibition of his capability of payment. Yes, I said earlier also. I am just more clarifying that you might say.
Okay, so you are saying the operational creditor liability will
Then
never
everything you
appear
have to
in the repayment plan.
yeah, everything to be considered, and vis-a-vis his source of income or assets available with him. So by this way, in the repayment plan, he has to show that he has the capacity to pay the financial creditors. Okay.
Okay.
So now we come to the provisions for bankruptcy. So who is bankrupt? My voice is audible, no, I believe. So who is bankrupt? As per section 79(3), bankrupt means a debtor who has been adjudged as bankrupt by an order. Each of the partners of a firm where the bankruptcy order has been made against the firm. Any person adjudged as an undischarged insolvent. So as per the I said that the section 79(3) gave the definition for the part 3, that is individual insolvency. And as per the section 79(3), the bankrupt is defined accordingly. Now, application for bankruptcy. Direct application for bankruptcy is not allowed. Insolvency process is a precondition. A bank cannot directly apply for the bankruptcy of the personal guarantor. He has to initiate the insolvency resolution process for the personal guarantor. If it is failed, in 3 scenarios I have told you, application rejected, or the plan is not approved, or the plan is approved but not implemented. In this, under these 3 scenarios, the bankruptcy application can be filed. Application can be filed both by creditors or debtors. Debtors can also file the application for bankruptcy. Creditor may file the application either individually or jointly. In case the debtor is a firm, the application may be filed by any of the partners. When the debtor is filed his application, and if it is a firm, any of his partner can file the application. The application has to be filed within 3 months from the date of order passed by the adjudicating under section 100 subsection 4, that is rejection of application, or section 115 subsection 2, that is non-approval of repayment plan, or section 118(3) is it the non-implementation of the repayment plan, as the case may be. So when this has happened, or order passed by the adjudicating, and within 3 months of that order, the application for the bankruptcy is to be filed. Application may propose an insolvency professional to act as bankruptcy trustee. The application shall not be withdrawn without the leave of adjudicating authority. In fact, there is no such provision for withdrawal, but there is a provision for modification of the order. Will come. Interim moratorium commences once application is filed. Then creditors or creditors is entitled to file an application when the application for the insolvency process is rejected by the adjudicating authority under section 104. Both the debtor and creditors is entitled to apply for the orders under section 115(2) passed by the adjudicating authority by recording the rejection of implement plan in the meeting of the creditor. The debtor or creditor whose claims have not been fully satisfied. Debtor or the creditor whose creditors whose claim have not been fully satisfied and an order has been passed by the adjudicating authority under section 118 subsection 3 mentioning that the repayment plan has not been completely implemented, then the debtor or that creditor can file the application for bankruptcy. So these are the three scenarios when the bankruptcy application can be filed. Bankruptcy order. As per section 126, the adjudicating authority shall pass a bankruptcy order within 14 days of receiving the confirmation or nomination of the bankruptcy trustee. So once the bankruptcy trustee is appointed, so within 14 days of that appointment, the adjudicating authority will pass the bankruptcy order. The adjudicating authority shall provide a copy of the application for bankruptcy and a copy of the bankruptcy order to the bankrupt, creditors, and bankruptcy trustee. So all will get a copy of the application and the copy of the order. Definitely, when the application is filed by the no, so in all cases, bankruptcies are better. Yeah. So the applicant shall provide the copy of the application for bankruptcy and the copy of the to all bankrupt creditors and the bankruptcy trustee. The bankruptcy order passed by the adjudicating authority under section 126 shall continue and to have effect till the discharge order is passed under section 138. The order is valid from the date of making the order till the discharge order is passed. Modification or recall of bankruptcy order. As per section 142, adjudicating authority on an application or suo motu. Condition is that is appear to the adjudicating authority that there exists an error apparent on the face of the order. Both the bankruptcy date and the expenses of the bankruptcy have, after making of bankruptcy order, either have been paid for or secured to the satisfaction of the adjudicating authority. Look, just very carefully read this provision. Once the suo motu, there is an error apparent from the order, face of the order, you can recall or modify the bankruptcy order. Otherwise, both the bankruptcy date, means that amount, and the expenses of the bankruptcy have, after making of bankruptcy order under section 126, either have been paid or secured to the satisfaction of adjudicating authority. Adjudicating authority is satisfied that yes, necessary provision has been made by which the payment is secured, he can recall or modify the order. Effect of modification or recall: sale, payments, etc. made by the bankruptcy trustee remain valid. Obviously, yes, if something is sold in between or if any payment made by the bankruptcy trustee, all those things are valid. Property of the bankrupt shall vest in such person as the adjudicating authority may appoint or may revert to the bankrupt on terms as directed by the adjudicating authority. So the bankrupt property, either adjudicating authority pass the order that it will be vested in the hand of other person, or it will go back to the bankrupt himself. But the terms, as per the terms and conditions, the adjudicating authority mentioned in his order. Order binding on all creditors so far, it relates to the bankruptcy date. So in case of bankruptcy, this order will be binding on everybody related to the bankruptcy date. Will come the definition of effect of the bankruptcy order. As per section 128, on passing the bankruptcy order, the estate of the bankrupt shall vest in the bankruptcy trust. Similarly, like your liquidation, the liquidation estate vested in the hands of the liquidator. The estate of the bankrupt shall be divided amongst the creditors. A creditor of the bankrupt indebted in respect of any debt claimed by a bankruptcy, claimed as a bankruptcy debt, shall not initiate any action against the property of the bankrupt in respect of such debt, or commence any suit or other illegal proceedings or other legal proceedings, except with the leave of the adjudicating authority and on such terms as the adjudicating authority may impose. So after this, I mean, we see that moratorium is started and nobody can initiate any action, legal action for these properties. The bankruptcy order shall not affect the right of any secured creditor to realize or otherwise deal with his security interest, provided he has action to realize his security within 30 days from the bankruptcy commencement date. So here, friend, the secured creditors has the option, what as per what is mentioned in section 52 of IBC, that when liquidation starts, the secured creditor can realize his security interest. Similarly, here also the security interest can be realized by the secured creditors, but the time period here is very short. It is only 30 days from the bankruptcy commencement date, that is bankruptcy order. He has to realize, otherwise he will go back to the bankruptcy estate. Where the bankruptcy order has been passed against a firm, the said order shall operate against each of the individuals who as on the date of the order is a partner of the firm. So here it covers all the partners of the firm as on the date of the order. Now it is a very, very important thing we are discussing. We have discussed the repayment plan. I request you kindly go through this very carefully. We have discussed the repayment plan under the process, under the insolvency resolution process for the personal guarantor. Now, in case of bankruptcy, a statement of financial positions is required to be prepared. It is not repayment plan, it is a statement of financial position. According to section 129, where the bankruptcy order has been passed based on the application filed by the creditor, the bankrupt shall submit his statement of financial position to the bankruptcy trustee within 7 days from the bankruptcy commencement date, as per the format prescribed. A specific format is given for this, for presentation of this statement of financial position. Such statement also provide a way to track the past financial history of the debtor and helpful to find vulnerable transactions. So as if you see the format, it not only includes the current position, but also the past financial history of the bankrupt has to be provided in these financial positions, which serve as a yardstick to find whether any avoidance transaction has been conducted by the bankrupt or not. Where bankrupt is a firm, the partners on the date of the order shall submit a joint financial position of the firm as well as their individual financial positions. It's a little bit harsh for the firm because they are not only the firm's financial position, obviously, no, they have the unlimited liability, these partners of the partnership firms. So partners have to give the financial position of their own also. The bankruptcy trustee may require the bankrupt or any other person to provide in writing further information explaining or modifying any matter contained in the statement. So bankruptcy trustee has that power. Penal provision prescribed under section 186A for 1, false representation, or 2, willful omission or concealment while providing any information during bankruptcy process. So there is a particular section 186, and as per the provision of that section, if any false information is given in the statement of financial position, or if there is any willful omission or concealment, it is, I mean, the necessary action can be taken for this purpose. Now we come to the word bankruptcy debt. What is bankruptcy debt? It is also very important with reference to financial statement, because financial statement will show the debt also. What we have just now discussed, it also reflects here. Bankruptcy debt, section 79(3), in relation to a bankrupt, any debt, and I repeat, any debt owed by him as on the bankruptcy commitment date. So my comment that bankruptcy is person specific, I think it can be justified by reading this provision, because it says any debt owed by him as on the bankruptcy commencement date. So it is person specific. Any debt for which he may become liable after bankruptcy commencement date, but before his discharge by reason of any transaction entered into before the bankruptcy commencement date, and any interest which is part of the debt under section 171. So for all this is considered as the bankruptcy debt for the bankrupt. Now section 179(15) says that what debts will not come under the purview of the bankruptcy debt, which is called excluded debt. It is these are maintenance to pay any person under any law. Any, the alimony, everything, maintenance, any court order is given for the maintenance, you have to pay something for the maintenance of any person. Those liability will not come as a debt in the bankruptcy debt. Liability with respect to a student, it will not come under the bankruptcy debt. Fine imposed by court and tribunal, because even if you are discharged, these liability that person will carry with you. Damages for negligence, nuisance, or breach of a statutory, contractual, or other legal obligations. Any other debt as may be prescribed. So these things are called the excluded debt, which will be excluded while calculating his bankruptcy debt. Similarly, bankruptcy assets also mentioned in section 79(14) rule 5, that unencumbered personal ornaments of the debtor or his immediate family that can not be parted with in accordance with religious usage. So if there is any unencumbered personal ornaments, the bankrupt or his immediate family has, that cannot be parted with, like your, for example, that I can say that Mongol Sutra, the Indian lady, they wear the Mongol Sutra. So if it is a gold chain, of that kind, and which has to be kept for a religious purpose. So as per the provision of this section 79, they said it will be considered as an excluded asset. But one cap is mentioned in the code, that is up to rupees 1 lakh. Up to rupees 1 lakh is personal ornament which cannot be discharged due to the religious usage, is considered as the excluded asset. Unencumbered life insurance policies, pension plans, these are also excluded assets. Unencumbered single dwelling unit up to 20 lakhs in urban areas or 10 lakhs in rural areas. Unencumbered tools, vehicles, equipment necessary for employment, business, or vocation. Unencumbered furniture, equipment necessary for domestic needs. So all these things you cannot consider for making your statement of assets. These are considered as the excluded assets for the banker. Next is public notice for inviting claims. We have already seen under section 110 that public notice is made for inviting claim from the creditors. Similarly, for bankruptcy process also, the adjudicating authority shall send notices within 10 days of the bankruptcy commencement date to the creditors mentioned in the statement of financial position. Here it is all related to the person. Statement of financial position submitted by the bankrupt or the application submitted by the bankrupt. Such notice shall include such matters and details as may be prescribed. Issue a public notice inviting claims from the creditors. The public notice so issued shall include the last date up to which the claim shall be submitted and such other matters and details as may be prescribed. I think it is 14 days. Within 14 days, the creditors has to file that claim. Such public notice shall be published in leading newspapers, one in English and another in vernacular, having sufficient circulation where the bankrupt resides, affixed on the premises of the adjudicating authority and placed in the website of the adjudicating authority. So by this way, the public notice for the bankruptcy process for inviting claims from the creditors will be made. Preparation of the list of creditors. The creditors
Sir,
yes, tell me.
sir, sufficient circulation. Sufficient circulation. It is very subjective, no, sir.
Subject to means, it depends upon the, you have to see the regulations also. If you see the regulation, it is mentioned. You see that as may be prescribed. So suppose you have to substantiate your claim. It is meant by that. You have seen in the CRP cases also that when you file your claim, you have to attach all the documents by which your claim can be substantiated. Get me? So preparation of the list of creditors. The creditors shall register claims with the bankruptcy trustee within 7 days of the publication. Sorry, it is not 7 days of the publication of the notice. Issue notice by sending the same with all details. The creditor shall also provide such other information and in such manner as may be prescribed. So if required, the bankruptcy trustee may ask for the information. But bankruptcy trustee shall within 14 days of the bankruptcy commencement date prepare a list of creditors of the bankrupt on the basis of one, information disclosed in the bankrupt in his application and the statement of financial position and claims received. Friend, here I really invite your attention. It is categorically said that suppose no claim is received from any creditor, but it is mentioned in the statement of affairs, bankruptcy trustee has to consider it. Because now the person is discharged from his bankruptcy debt. So utmost care should be taken to include all the creditors for this purpose. That's why it is mentioned that list will be prepared on the basis of information disclosed by the bankrupt in his application and the statement of financial position and the claims received. Both the things to be considered by the bankruptcy trustee. Meeting of creditors. The bankruptcy trustee shall issue notice for meeting of creditors to be held not later than 21 days from the bankruptcy commencement date. The proxy voting, including electronic proxy voting, shall take place in such manner and form as may be specified. The bankruptcy trustee shall be the convener of the meeting and the quorum of the meeting shall be decided by the bankruptcy trustee. There is no specific provision in the code. It is mentioned that the trustee will mention about the quorum. The meeting shall be held and necessary resolutions to be passed for the establishment of a committee of creditors. What I said, that in the meeting, the committee of creditors will be decided. And to any other business as the bankruptcy trustee thinks fit. The minutes of the meeting shall be written and signed by the bankruptcy trustee and retained as a record of the bankruptcy process. The bankruptcy trustee shall not adjourn the meeting for any purpose for more than 7 days at a time. The creditors shall be entitled to vote on the resolution in accordance with their voting share as determined and assigned to them. The creditors who are not mentioned in the list of creditors and who have not been given a notice, and the creditors who are associated with the bankrupt shall not be entitled to vote. So in both the cases where their name is absent in the list of creditors and who has not been given any notice by the bankruptcy trustee, or the creditors who are associate, related party of the bankrupt, they are not entitled to vote in the meeting of the creditors. Composition of creditors has not been laid down in the code nor in the regulations. Voting share, though not mentioned, but may be in proportion to the share in total. In CIRP also we have seen that in the proportion of the total debt, their voting percentage is determined. Voting percentage for general meeting has not been given in the code or in the regulations. Section 134(3) provides for passing of resolution. Logically, it should be simple majority. So here it is not mentioned whether it is 66% or 75% or 51%. It is said that with the majority vote. So passing of resolution. So it is logically it is concluded that it should be a simple majority. Bankruptcy trustee shall intimate adjudicating authority about the constitution of committee of creditors within 3 days, as per regulation 22. Now completion or administration. The bankruptcy trustee shall conduct the administration and distribution of the estate of the bankrupt. The estate of the bankrupt is now vested with the bankruptcy trustee. He supervise the estate. He make the sale and distribute the money to the of the sale to the creditors of the bank. The bankruptcy trustee shall convene a meeting of the committee of creditors on completion of the administration and distribution and provide his report for the administration of the estate of the bankrupt in the meeting. The committee of creditors shall approve the report within 7 days of the receipt of the report and determine whether the bankruptcy trustee should be released. The scope of work of the bankruptcy trustee will be over if he is released by the committee of creditors. And that should be done within a period of 7 days from receiving report from the bankruptcy trustee. The cost of convening the meeting shall be made from the fund of the bankrupt trustee estate. Approval of creditors for certain acts. As per section 153 of the code, the bankruptcy trustee, after having the approval of the committee of creditors carrying on the business of bankrupt, initiate or defend legal proceedings against the debtor, accept sale considerations at a future time, mortgage or sell any property for raising money for payment of debt or the bankrupt, arbitration or compromise with respect to subsisting debts or any compromise or arrangement as may be considered expedient. For all these things, he required the approval from the committee of creditors, and that is the simple majority. Through a simple majority vote. Make payments or incur liabilities with a view to obtaining for the benefit of the creditors rights attached to any asset. Appoint the bankrupt to supervise the management of estate, carry on business, assist the bankruptcy trustee. So bankruptcy, it is open for the bankruptcy trustee to ask the bankrupt to supervise his or manage his estate or to help him in his work. But for that purpose, he requires the approval from the committee of creditors. He cannot have on his own appoint him to ask him to supervise the estate. Discharge in bankruptcy process. Section 138. Bankruptcy trustee shall apply to the adjudicating authority for a discharge order of the bankrupt on expiry of 1 year from the bankruptcy commencement date or within 7 days of the approval of committee of creditors of the completion of administration of the estate of the bankrupt, whichever is earlier. So there is a provision of the court that if the process for bankruptcy resolution continues for more than 1 year, the bankruptcy trustee should make an application before the adjudicating authority to discharge the bankrupt. So all the major activities should be complete. So the person will be immune, he will be discharged from all his bankruptcy debt. So the person can start his activities afresh. Because we'll see that there are some restrictions on the bankrupt. So a person can come to the normal flow of his life after 1 year. That is the maximum time frame is given in the code, or it can happen earlier within 7 days on the approval of the committee of creditors about the completion of administration. That everything is done. Asset sold, dividend made, everything. The adjudicating authority shall pass the order. A copy of the said order to be provided to the board for record. Board means here IBC. The discharge order shall release the bankrupt. Once again, I am saying, you please carefully see this one. The discharge order shall release the bankrupt from all the bankruptcy debt, provided it does not affect the functions of the bankruptcy trust. So if it is affect the function, then he will be not discharged, but otherwise the person will be discharged from all his bankruptcy debt, means all his liability. There will be no creditor for him, which is not in the case of that insolvency process for the personal guarantee. He is discharged only for the debt, it is mentioned. But here it is mentioned from all bankruptcy debt. It will be DBT. The discharge order shall not release the bankrupt from any debt incurred by means of fraud or breach of trust to which he was party and from his excluded debt. We have seen that excluded debt will not be will not come under the bankruptcy debt. Yeah. Disqualifications of a bankrupt. As per the code, section 140, a bankrupt with effect from bankruptcy commencement date disqualified from being appointed or acting as a trustee or representative in respect of any trust, estate, or security. So when the bankruptcy order is passed, from that date up to the date of discharge, the person cannot be appointed or act as a trustee or representative in respect of any trust. Appointed or acting as a public servant, he cannot act. Elected to any public office where the appointment to such office is by election. No MLA MP can be out of a bankrupt. elected or sitting or voting as a member of any elected or sitting or voting by sitting or voting as a member of any local authority. Similarly, he cannot be a member elected, or he can be nominated for a position in the municipal corporations also, all the local authorities. He cannot be. So these are all the disqualified. All these things he will be disqualified as a bankrupt. Also, he cannot be appointed as a director unless he is undischarged insolvent. Restrictions on a bankrupt. As per Code Section 141, a bankrupt which affect the bankruptcy with effect from bankruptcy commencement date cannot be a member of a professional body or act as director or promoter. So he cannot be a member of professional body, no CSS, or act as a director or promoter. That's why I say that this period, maximum period is 1 year. After that, he can start his life afresh. Cannot travel overseas without the permission of the adjudicating authority. Cannot create any charge on his or her estate without prior approval of the bankruptcy trustee. Cannot take any charge of his estate and anything and everything is covered. Cannot take further debt without approval of the bankruptcy trustee. Must inform business partner of ongoing bankruptcy. Must inform the party before entering into any transaction, any contract. And the value here, the cap value here is rupees 1 lakh. So if any agreement if he signs is more than 1 lakh, he has to inform that other party that he is a bankrupt. Cannot maintain any legal action or proceedings in relation to bankruptcy debt without previous sanction of the adjudicating authority. So all these things, apart from the disqualification, all these restrictions are also imposed on a bankrupt. And now what is meant by bankruptcy estate? Creditor shall register claim with the bankruptcy trustee within 7 days of the publication of public notice by sending the same with all details. The creditor shall also provide such information and in such manner as may be prescribed. The bankruptcy trustee within 14 days from the bankruptcy commencement date prepare a list of creditors. Information, I think it is already a repetition. Preparation of list of creditors shall register. Priority, okay, we have seen the section 53, which shows the waterfall mechanism in case of liquidation. Bankruptcy is another form of liquidation for the individual. But instead of saying it is a waterfall mechanism, it is mentioned under section 178 as the priority of payment of debts. The cost and what is the how it will be paid, all the proceeds on the bankrupt estate. Firstly, the cost and expenses incurred by the bankruptcy trustee for the process in full it is to be paid. Then workmen dues for a period of 24 months prior to BCD, bankruptcy commencement date, and dates of the secured creditors. There is no difference between the unsecured, financial or operational creditors. It said all the secured creditors will be paid within a period of 24 months prior to BCD. All the secured creditors will be paid. This 24 months is for workmen dues. Wages and any unpaid dues to employees other than workmen for a period of 12 months prior to BCG. Any amount due to government, central government or state government for 2 years preceding to BCG. All other debts and dues including unsecured debts. Interest on debt for period outstanding since bankruptcy commencement date. So in this fashion, the payment will be made. Deposit to insolvency and bankruptcy fund. The bankruptcy trustee has to make application to the adjudicating authority within 3 days of submission of final report for an order to deposit any unclaimed dividend or undistributed asset or any other balance amount payable to the creditors left with him, so that it can be deposited with the IBD. That amount can be kept with the bankruptcy trustee. Submission of statement. The bankruptcy trustee shall submit statement including name, address, amount, value of asset, etc. So that statement should be prepared and submitted by the bankruptcy trustee. So now if you see the timeline for bankruptcy trustee, if you consider T0 is the order passed by the adjudicator to the bankruptcy, it is considered as the commencement date, and T1, that is T0 plus 7, the adjudicating authority will ask the board in IBBI for appointment of RP. Then T1, T2 is the T1 plus 7, that adjudicating authority to appoint RP. T3 is T2 plus 10, RP to submit report under section 99 to adjudicating authority on submission of admission of application. T4 is equal to, no, sorry. I'm sorry. This is a timeline for personal guarantee, not for the bankruptcy. So, friend, now we will discuss about the adjudicating authorities. As per the code, there are two authorities who can adjudicate the insolvency proceedings for the personal guarantor or the bankruptcy resolution. One is NCLT under section 60 and other is GRT under section 179. So under NCLT, the corporate debtor, that is company and LLP comes, and personal guarantor to corporate debtor. And under DRT, individuals in business or otherwise other than personal guarantor will come, and partnership firms other than LLP will come. But here it is a very simple structure. There are some complications too. You know what's happening, what we have discussed. A personal guarantor's guarantee can be invoked and application can be filed against him. If it is so, then the petition for the petition against the personal guarantor to be filed to the GRT where the personal guarantor resides. So in that case where that corporate debtor is not touched, only the personal guarantor guarantee invoked and petition filed against him, it will be filed to the DRT where he resides. But if subsequently the CIRP process is filed for the corporate debtor, then the petition for the personal guarantor will also be transferred to the NCLT where the registered office of the corporate debtor situated. Here. So this is in a complex scenario where the personal guarantor may be, trial before DRT, but as soon as the CRLT process for the corporate debtor starts, it will be transferred to the NCLT. Similarly, suppose the CRLT process is initiated against the corporate debtor, and then after that the guarantee is invoked and the petition is filed against the personal guarantor, the entire thing will come to NCLT for adjudication. There DRT has no role to play. So this is the structure for the adjudicating authority of NCLT and DRT. Now I have prepared some slides showing the difference between the personal insolvency. What is the time? We have time. So very shortly, application by creditors, no classification, personal insolvency, no classification of creditors, but in corporate insolvency, application varies from the types of the creditors. Withdrawal applications, yes, 90% consent of the creditors, yes, 90% consent of the creditors. Committee of creditors, no concept of COC. At a list of creditors is prepared, mandatorily constitute a committee comprised of the unrelated financial creditors. Meeting of creditors not mandatory, shall be conducted if deemed necessary by RP. Certain conditions are there. Mandatory to conduct the meeting of COC. Interim moratorium, yes, but in CIRP, no. Approval of plan requires 75% assent of the creditors present and voting. Again, I'm saying it is mentioned present and voting. And for corporate insolvency, it requires 66% assent of COC. Rejection of plan application for bankruptcy may be filed and leads to compulsory liquidation. There is no compulsory liquidation in case of personal insolvency. The financial year needs to file the bankruptcy application. Then the difference between the liquidation versus bankruptcy. The manner of intimation automatically triggered under section 33 in case of liquidation, but in case of personal bankruptcy, creditors or debtors become entitled to file bankruptcy under section 100. Rejection of insolvency. We have all discussed. We have all reversibility stroke modification or recall, no specific provision right to appeal against AA's order under section 61. There is no provision for modification recall under liquidation. You can only file application under section 61. But in case of personal bankruptcy, possible. Interim moratorium, no, but here it is yes. Moratorium section 33 on liquidation order being passed, and under section 128 on bankruptcy order being passed. Role of IP, it is liquidated and it is called bankruptcy trust. Estate of debtor, liquidation estate held by liquidator as fiduciary for benefit of all creditors. Section 36, estate of bankrupt, vested to the bankruptcy trustee, section 100. Manner of vesting of estate, no conveyance assignment, the estate is constructive. Under section 154(2) provides that there is no need for conveyance assignment or transfer for vesting of property in the bankruptcy trustee. In both the cases, it is constructive. Involvement of creditors in liquidation, liquidator has to constitute a stakeholder consultation committee with the creditors. There is no provision for committee of creditors during liquidation. In case of personal bankruptcy, considerable meeting of creditors is summoned and a committee of creditors is appointed for approval of the report on administration of the estate. The bankruptcy trustee requires approval of the committee of creditors for several acts we have already discussed, and the committee of creditors decides on the release of bankruptcy trustee. That also we have discussed. Priority of payout from estate, section 53, the waterfall mechanism, and here it is 178, priority of payment. Final stage dissolution, the entity loses its existence. It is very important. Here it is discharge. Release the bankrupt from all his bankruptcy debts. Where there is no existence of the corporate debtor after the liquidation is over, here the person, individual person, is released from all his bankruptcy debt once the bankruptcy process is over. So if you have any question, I can answer, but any question you have? Hello? Any question?
Sir, your presentation is very good. very nice compilation
Thank
of
you,
all
sir.
the provisions of the code. Is
Thank you, sir.
of great help. Thank you, sir.
Thank you, sir. Thank you.
Thank you, Partha sir, for sparing a valuable time for us in
Thank
this first slot of today's workshop.
Yeah.
And I am sure participants must be enlightened with the words and with the knowledge that you've shared with them.
Thank you, sir.
Participants, if you have any question, then we can take up those questions. Otherwise, we can have 1 hour break and we'll meet 1:30 p.m. again for the second slot of the workshop.
Thank you, sir, for nice presentation.
Thank you so much. Thank you. If you have any query, you can. I think you will have my contact details, email ID. You can ask me. Just request you that give the reference of this program so that I can realize and that yes, this was discussed.
Will you be sharing your presentation, sir?
I'll share with the ICS.
Thank you.
Thank you so much. Thank you. So we'll meet again at 1:30.
Thank you,
Yes, sir.
Partha sir. We'll meet again 1:30 p.m. for the next slot of the session.
Okay. Thank you so much.
Thank you so much.